Hey everybody, I'm Valerie Zammitti of Zammitti Law, where we provide peace of mind to families through estate planning, elder law, and probate matters. Today we're going to talk about the top 4 misconceptions when it comes to estate planning. Before we get there, however, if you have any questions about estate planning or probate, you can reach out to us for a free conversation at yourplanningattorney.com. That's yourplanningattorney.com. Now, misconception number 1 is that an estate plan is only for the wealthy. This couldn't be further from the truth. First off, once you reach 18 years of age, everybody should have an incapacity planning package, including a financial power of attorney and health documents. This ensures that if you ever became incapacitated, you have the right parties there to help make the decisions for you. An estate plan, whether it's a will or a trust, also allows you to set up your wishes upon your passing relative to asset distribution, as well as who's in charge of taking care of those things, as well as if you have children, the guardians that you would choose to take care of your kids if, God forbid, something happened to you beforehand. It also meets your other goals. For instance, if you want to have some asset protection from potential long-term care or other means. It also allows you to designate and make sure that you are protecting your beneficiaries for asset purposes and giving them as much creditor insulation as you can. The type of plan you set up may be for privacy, if you would prefer higher privacy and you implement a trust. Your other goals will determine the rest of your estate plan. But it is not just for the wealthy. It is for anyone who wants to take care of themselves, make sure they have the right decision makers in place, and to set it up properly for those who will be receiving the assets afterward. Common misconception number 2 is that a will avoids probate. This is not true. A will is actually a document that you would prepare ahead of time, yes, but specifically will go through probate. A trust is the designated estate planning document that helps avoid probate if it's utilized correctly. If you do have a will plan, the individuals you've designated will need to take that document at your passing to the local circuits court where you reside or did reside to start that probate process through the courts. Again, to avoid that, a trust plan would need to be implemented and properly funded and utilized. Note, there are some assets of yours that may not go through probate, such as a retirement account, life insurance, if, again, you have proper beneficiaries designated there. Common misconception number 3 is that estate planning is only set up for older adults. That's not true. Again, I've already mentioned that once you reach 18, you need to have your incapacity planning documents set up for financial and health purposes. Young families as well, when you have minor children, if something should happen to the parents before those young children reach age 18, they need to have the guidance not only for them as individuals and a guardian over them as a person, but also someone to take care of any of the finances that come their way. The best way to do this is to set up your estate plan to designate who those parties are. Otherwise, you're just leaving it up to happenstance and whomever presents themselves and puts themselves forward and the court allows. You don't really then get to say. Lastly, the 4th common misconception is that estate planning is a one-time event. It is very important. And again, I'll give you kudos for any of you out there who have set up your estate plan initially. But it is really important to make sure you touch base, and hopefully your attorney is doing this already, but touch base once a year just to say, like, checking in, seeing how things are going, nothing has changed significantly in your life, so forth. If something does change, you have to make sure you're talking about those things to see if it affects your estate plan and adjustments need to be made. At a minimum, in my eyes, and this is how we practice, every 3 years, you should have a little more of a formal conversation to make sure you go through who you had previously designated to be in charge, what your wishes are and how they were laid out under your estate plan. And that way, if there are adjustments, you can address them and make sure they are meeting your needs at that time. Life shifts, and so should your estate plan. We hope this information is useful. And as a reminder, if you have any estate planning or probate questions and would like to reach out to us for a free conversation, you can do so at yourplanningattorney.com. That's yourplanningattorney.com. Thank you so much for listening. And if you found this information useful or think someone else may, please share, like, and subscribe where appropriate so nobody misses out. Again, I'm Valerie Zammitti of Zammitti Law, where we provide peace of mind to families through estate planning, elder law, and probate matters. Take care. Thanks.